Before I begin reading my reply to Defendant Alphabet Incorporated's proposed statement of facts via counsel for the defendants, Sopen B. Shah, I have to question why this document was not filed with the Clerk of Court, which I took upon myself to file a copy of the defendant's proposed statement of facts and my reply with the Federal Clerk of Court. This document is extremely important as it poses arguments to the assigned judge as to why Defendant Alphabet Incorporated should be removed as a defendant, which, upon further research, appears to be the case. All other arguments posed by the defendant's legal counsel, I am in 100% disagreement with and stand by all arguments I have presented via claims, evidence, and submitted briefs in opposition to or by court order. Plaintiff's response to Defendant Alphabet Incorporated proposed statement of facts. Attention Judge J.P. Statmuller and the Federal Clerk of Court for the United States District Court for the Eastern District of Wisconsin. I, Plaintiff pro se in this legal matter, am submitting this response to Defendant Alphabet Incorporated's proposed statement of facts via Sopen B. Shah of the Perkins Coie law firm. First, Sopen B. Shah reaffirms her stance regarding the court's lack of jurisdiction over this case, which I wholeheartedly disagree with, as the plaintiff firmly stands by the arguments presented in the plaintiff's subject matter jurisdiction brief, citing local, state, and federal statutes proving the court has jurisdiction over the plaintiff's case, docket number 39. Second, Sopen B. Shah states I have failed to state a single claim against Alphabet Incorporated. This is true, as I have had zero interactions with Alphabet Incorporated and was solely included as a defendant based upon Alphabet Incorporated being the parent company to subsidiary defendants Google LLC and YouTube LLC, based upon a principal example that if an employee commits an egregious wrongful act against another employee or customer, the company in which the employee was hired is to be sued due to the misconduct of its employee. Third, Sopen B. Shah continues to cite the Communications Decency Act 47 United States Code Statute 230 C1 and the First Amendment, barring all claims made by the plaintiff. The Communications Decency Act and the First Amendment should not afford protection to anyone when falsehoods are stated against anyone or anything concerning issues that do not actually prove the actions to be indecent, particularly when there has been evidence submitted to refute any false claims of indecency. Fourth, Sopen B. Shah continues to state the plaintiff's complaint does not contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face against the defendants Google or YouTube. The plaintiff is in complete disagreement with this statement due to the large amounts of digital evidence submitted with the complaint and to the defendants that corroborate the plaintiff's claims, making all claims factual against the defendants. Fifth, I am going to address page 2, paragraph 4, line 2, which reads, the court asks the parties to brief subject matter jurisdiction because the complaint indicated that this case might not meet the amount and controversy requirement of more than $75,000. Please see attachment number 1, a copy of the civil docket report under the heading Demand, which reads 25,000 and is quite possibly another data entry error, as the plaintiff is not suing the defendants for $25,000 in punitive damages. The plaintiff is suing the defendants for $25 million in punitive damages and is quite possibly the reason why the court is questioning subject matter jurisdiction over this case, which it does have, based not only on the actual amount in controversy, but also on diversity of citizenship and among other information contained within the subject matter jurisdiction brief submitted by the plaintiff on March 30th, 2022, docket number 39. Finally, according to source, though the law in each state may differ, the general principle of corporate law in the United States federal courts is that a parent corporation is not liable for the acts of its subsidiaries. Noting the plaintiff could not successfully locate information regarding Wisconsin law governing parent to subsidiary relationships and filed lawsuits, if Defendant Alphabet Incorporated is removed as a defendant upon a ruling from the court, the plaintiff will immediately submit a third amended complaint reflecting Google LLC and YouTube LLC as defendants due to the plaintiff's past interactions with Google LLC and YouTube LLC, which yielded unresolved and unfavorable results, and the plaintiff will vehemently pursue the complaint filed and stands by all claims, evidence, and briefs submitted in opposition to or by court order 100%, and will also exhaust all appeals afforded the plaintiff as of right.